She built the curriculum. The school stole it and erased her name. She built an entire curriculum from scratch. Then the school she trusted took it, rebranded it, and sold it without her name attached to anything. The plaintiff was a former adjunct professor, a woman who had spent 11 years working in educational technology before partnering with a mid-sized private academy in the spring of a recent academic year. The school, a well-regarded institution serving grades 6 through 12, had approached her after seeing a presentation she gave at a regional education conference. They were impressed. They said so in writing. They wanted her to co-develop what they called a flagship digital literacy program, something that would set them apart from competing schools in their district and potentially license to others nationwide. What followed was 18 months of collaborative work. The plaintiff threw herself into it. She developed lesson frameworks, assessment rubrics, interactive modules, and a proprietary methodology she called layered inquiry learning, a structured approach to teaching critical thinking through digital media. She documented everything. She invoiced the school monthly at an agreed rate of $4,200, which they paid without dispute. When the program launched internally, administrators called it transformational. Parents raved. Students tested significantly higher on media literacy metrics than the national average. Then the school filed for trademark protection on the program name. Without her, the plaintiff sued for $2.3 million, a figure representing lost licensing royalties, reputational damages, and the estimated commercial value of the intellectual property she claimed was hers alone. Her attorney argued that the invoicing arrangement proved she was an independent contractor, not an employee, and that under independent contractor law, the creative work product belonged to its creator. She hadn't signed a work-for-hire agreement. She had signed a consulting agreement. The distinction, her lawyer told the court, was everything. Her testimony was measured but emotional. She described staying up past midnight refining lesson plans while the school's internal staff contributed almost nothing to the actual architecture of the program. She had emails, she had version histories on shared documents, she had her name on every draft, until the final published version where her credit had been quietly reduced to a single line in the acknowledgement section. The school's defense was equally compelling. Their attorney argued that the plaintiff had fundamentally misunderstood what she was hired to do. She wasn't building something of her own, they contended. She was executing a vision that the school's curriculum director had originated and that the institution had funded entirely. The school had provided the students, the classrooms, the administrative infrastructure, the technology budget, and, critically, the iterative feedback that shaped every stage of development. Without the school, there was no program. It didn't exist in a vacuum. It existed because of them. The curriculum director took the stand and testified calmly that she had sketched the original concept, including the phrase layered inquiry, in a meeting more than 2 years before the plaintiff was ever involved. She produced a meeting agenda from that session. She produced budget proposals. She projected quiet confidence. Then came the text messages. The plaintiff's attorney had subpoenaed the curriculum director's personal phone records after a former school employee, someone who had left the institution under difficult circumstances, reached out voluntarily. The texts, exchanged between the curriculum director and the school's head of communications in the weeks before the trademark filing, told a different story. In one exchange, the curriculum director wrote, "She's going to find out eventually. We need to make sure our paperwork looks like this was always ours." The communications director replied, "Just make sure there's nothing with her name on the final docs. The consulting agreement gives us enough cover." The courtroom went quiet. The judge, a 30-year veteran of civil litigation, didn't need long. She ruled in favor of the plaintiff. The consulting agreement, she found, did not constitute a work-for-hire arrangement. The intellectual property belonged to its creator. The text messages, she noted in her written opinion, demonstrated not just oversight, but deliberate misappropriation. The school was ordered to pay $185 million in damages and to formally credit the plaintiff as co-creator on all published and licensed versions of the program. The trademark filing was invalidated. The curriculum director resigned within 2 weeks of the verdict. The school publicly apologized and issued a revised licensing agreement that included the plaintiff's name going forward. Several educators who had used the program reached out to her directly. Some called her a hero. The plaintiff said in a later interview that she didn't feel like one. She felt tired. The former employee who provided the tip never publicly identified herself. The program, ironically, is now considered one of the most successful K-12 digital literacy curricula in the region. Both sides contributed to what it became. Only one side tried to erase the other, which raises the question the comments section always gravitates toward in cases like this. If a collaboration produces something genuinely great, does it matter who gets the credit? Or does the attempt to steal that credit poison everything the work stood for?